Mr. Hurd, you may proceed.
Thank you, Your Honor. May it please the court. Your Honors, this court should reverse the district court's grant of summary judgment to the state of Iowa affirmed by the Court of Appeals in State v. Linn for three reasons. First, application for investigative services violated due process pursuant to State v. McGee. Second, the denial of the application for investigative services effectuated a right to the denial of counsel constructively. And third, on this record, a genuine issue of material fact existed as to the need for a battered women's syndrome expert. I think it's helpful to focus the court's attention on the motion for expert fees, which I would consider to be one of the most important filings in this case. This case is unique from many of the cases cited by the state in their brief and cases on which this court has denied further review and claims of constructive denial of the right to counsel, including Jones, including the other cases. In the motion for expert fees in this case, counsel represents to the trial court that neither applicant nor his attorney has the expertise required to evaluate this claim of battered women's syndrome with regard to the legal and causation requirements of this claim. That should have given the court cause for a lot of concern. Unlike a number of cases cited by the state, unlike the Jonas case, and unlike the...
Here's a question I have for you. As I looked at the record, it looked like there were two different motions for appointments of expert filed by two different lawyers below. Is that right?
That's correct.
But then when the state actually moved for summary judgment and the resistance was filed, there was nothing in the resistance about, hey, I've got a motion pending for an expert. I need an expert to respond to the motion or anything like that. And what's a district judge to do? I mean, are they supposed to go back and read the whole file? I'm kind of sympathetic to the judge in this situation. You see where I'm coming from?
I understand that, but I think the critical aspect of this case is from my recollection of the docket, the motion for expert fees was filed at the same time as the resistance. It wasn't a long, attenuated motion that had been lingering on the docket forever. At the precise same moment that the resistance is filed, a request for expert fees is tendered to the court.
A gap in time, but I may be misreading the record.
Whether they're simultaneous or not, or close in time, would you agree that defense counsel never raised it up and said, hey, judge, there's a pending motion out there?
I agree that defense counsel didn't raise it up, but I don't agree that that's a problem that should effectuate this court from finding that there was effectively a denial of counsel here. And the reason is this. In Rickey and in Jones, there was not an indication as here where the trial counsel on the PCR indicates to the court, I don't have the professional competence to even investigate this claim. In the Rickey case, there was a one-line, which is electronic and the briefs are available, there was a one-line resistance to the summary judgment. Comes now the applicant and resists the motion for summary judgment. Doesn't represent to the court, whereas here affirmatively, that counsel doesn't exercise professional judgment in supplementing the resistance. And in the Jones case, the record is even more clear. Counsel in the Jones case, there was a hearing in the Jones case, and counsel in the Jones case said to the court, the reason that I haven't filed a resistance is I've determined based on the exercise of my professional judgment that supplementing the resistance to summary judgment would be frivolous. But as the Jones court noted, the applicant in Jones was afforded a number of other due process rights, which allowed the state to meet the due process burden. There was a hearing in Jones in which the applicant was present via telephone. In Jones, the applicant's counsel reminded the applicant that the applicant had the right, pursuant to Gamble, to raise their own pro se claims, and the applicant had the opportunity to speak to the court about those claims, and the court addressed those claims. None of those protections applied to the applicant in this case. In this case, the application was submitted non-orally, in no proceeding where the applicant participated via telephone, and where we have an active filing on the trial court where trial counsel says, I don't have the professional competence to investigate this claim. I mean, under Latto, structural error can occur from not just the actual denial of counsel, but the constructive denial of counsel as well. And I'd submit to the court that where counsel's made a filing of this nature, this case is different than Ricky. This case is different than Jones. A filing of this nature affirmatively demonstrates the counsel is constructively denied, even though actively present, if the counsel that's provided does not have the expertise required to evaluate the claim with regard to the legal and causation requirements of the claim.
How do you respond to the state's argument that the facts are inconsistent with battered women syndrome here? Her boyfriend has already agreed to move out. She gave inconsistent accounts of what happened.
Well, I'll be the second attorney today to disclaim that I'm not a medical doctor, but I think that there is certainly a genuine issue of material facts on whether the facts here are consistent with battered women syndrome. And what I would note for the court is a couple things. First, this is not a case that proceeded the jury only on the theory that the shooting was accidental. The theory of justification was actually submitted to the jury in this particular case. Second, as I noticed in my additional authorities, the power and control wheel that's created by the Duluth Project, I think that's a secondary authority upon which the court can rely to determine there is evidence of potential battered women syndrome here. I think one of the flaws in...
With regard to that, my recollection from my review of the record, which is not complete by any means, I mean, there was a substantial trial, is she did not testify to any prior physical abuse by this man other than what happened that night that she shot him. Am I correct?
I think that's not correct. And I'm not going to stand here and say that it's the most overwhelmingly compelling battered women syndrome case there ever is. But there are a number of things in the record where she did testify to prior violence. It seems from her testimony she testified that the relationship became violent approximately 2 weeks before this incident occurred. But even beyond that, there are a number of other characteristics of violence that are present, that are explained when you apply the paradigm of battered women. There are many that are cited in the application for further review. One fact that I thought was fairly compelling, that if a battered women syndrome expert was assigned to this case, might be better explained, is something that happened immediately prior to the incident that led to Mr. Blanchard's death. It's that odd phone call that Mr. Scott received, and that's in the record at 463. And in the record at 463, Mr. Scott reports he received a phone call not from Miss Linn, but from Miss Blanchard. And the odd thing about this phone call is Mr. Blanchard says, "I shot Kathy Linn." And Kathy Linn is in the background laughing about it. Why I think that's odd and why I think that's explained in the paradigm of domestic violence is characterized by threats of harm. And it's not a coincidence to me that there's a threat of harm. That's this statement that I shot Kathy Linn is made in the presence of Kathy Linn. Jeff Scott testifies to that. But to a person who's in a domestically violent relationship, a threat of harm is a reminder of the harm that has occurred and its imminent presence within the relationship. That statement might be perceived by Mr. Scott and Ms. Crees as a joke, but to a woman in the situation of Kathy Linn, who's experienced violence, not only in the relationship with Mr. Blanchard, but also from her experience of having her sister be murdered by an abusive partner, and other experiences she's had in her life as were outlined in the record.
Well, let me ask this question. You're assuming the entire trial record was before the court. Was it offered into evidence?
The entire trial record is not before the court, insofar as I can see.
Right, and as I look at the summary judgment motion, and I'm going to share with you, as Justice Mansfield did, I've spent some time in the record, and I may not have complete mastery, but there was a motion for summary judgment filed, a naked motion, actually. The motion from the state had no record site at all. And then there was a statement of facts not subject to genuine dispute by the state. And then in the resistance, there was, your side filed a resistance, no citation to any facts. Then the district court said in its ruling, well, there's nothing been presented to me that suggests any evidence of battered woman syndrome. In one sense, arguably, it was correct, because if you look at the summary judgment package, you know, none of this recitation that you've just given me was presented to the court at that time. Now, am I right, my description of the record? And if I am right, where does that leave you?
I don't disagree that there wasn't a very good presentation at the trial court of the evidence in support of battered women syndrome. But I think the conclusions drawn by the trial court in evaluating what was before the court, which did include the trial transcript.
Why was the trial transcript before the court?
The trial transcript was included in an appendix that was attached to the summary judgment motion.
Whose
And
summary judgment motion?
the state's.
Oh, very good.
And I also think this court's prior precedents allow the court to assume that the court has used the trial
I
transcript.
tell you what, if it was attached to the summary judgment motion, that was something I didn't pick up on, and if it was attached to the summary judgment motion, then I think it's before the court for
Sure.
purposes of summary judgment.
I think one of the court's big hangups was the court found, and in citing its reasoning, most importantly, that Kathy Linn offered testimony that was inconsistent with a narrative of battered women syndrome. But for summary judgment purposes, the dispositive question is not whether all of the evidence in the record is consistent or inconsistent. The dispositive question is whether the evidence before the court, including the statements which might support a battered women syndrome defense and which might rebut it, generate a genuine issue of material fact.
On the question of whether counsel was competent, right? Trial counsel, that's an ineffective assistance claim.
I mean, on the question of whether the court abused its discretion in granting summary judgment.
Wait a minute. Your underlying claim in PCR, correct me if I'm wrong, but your underlying claim in PCR is the trial counsel failed to pursue a battered woman syndrome defense with an expert witness, and that caused your client prejudice, I take it.
Correct.
I'm right so far. Okay, so in order to prove that trial counsel was ineffective, you need to show two things. One, that a judgment was made below professional standards, and then two, that erroneous judgment caused prejudice. Were you with me so far?
Yeah.
Okay. The PCR court seems to have said, as a matter of law, where at trial a defense of accident is asserted, and she did claim it was an accident at trial, as a matter of law, it makes no sense to hire an expert to promote battered spouse syndrome because it's inconsistent with an accident theory. I think that's what that's how I read the PCR ruling.
That's how I read the ruling too, and the ruling is wrong because accident was not the only theory submitted to the jury. The jury also was instructed on the theory of justification. That was also advanced at trial. So by citing only on the accident theory and saying the record evidence is inconsistent with the theory of the case of an accident, the court's ignoring what the theories that were actually argued to the jury were, and which were actually submitted to the jury. On the theory of accident, the court made
Justification in what sense? I mean, was it justification in the sense of self-defense? Because I recall her version at trial was there was kind of this struggle and the gun went off and that was it.
Well, that was her version at trial. Also presented at trial was evidence that she feared, evidence that she fully intended to defend herself. The police officers who responded to the scene seemed to indicate that she made a variety of statements, some of which indicated a struggle, some of which indicate she shot the defendant intentionally. Both of those theories were pursued in this case, and that's why the court granting summary judgment in the PCR was short-sighted in focusing only on how, as a matter of law, when you advance solely an accidental theory, a battered women's syndrome expert is not helpful. The Ohio case cited in the state's brief reasons this out, but here it wasn't the theory solely of accident. Here, a dual theory of accident and justification was advanced, and therefore it was error for the district court to find no issue of material fact when the trial court instructed on the defense of justification. For these reasons, judges, we'd ask that you reverse the grant of summary judgment of the district court and the affirmance of the Court of Appeals and remand this case to the district court.
Mr. Hurd, thank you. Mr. Sloven.
Thank you, Mr. Chief Justice. May it please the court, counsel. Good morning. It's a privilege to be here. I want to start by talking about this defensive accident. It's her testimony, Ms. Linn's testimony, in the trial transcript attached to the motion for summary judgment that she did not intend to hurt or kill Mr. Blanchard. She testifies, her testimony indicates that she did not intend to shoot the gun.
The state goes on at great lengths to say, yes, you did, and offered a lot of evidence from a police interview and out in the porch and so forth to suggest you did shoot it.
Right.
And then the comeback is justification, the defense of justification.
And the problem is that once she says that she didn't intend to hurt or kill him, it becomes next to impossible for her to maintain any claim that she had a subjective belief that the use of deadly force was reasonably necessary to avert imminent serious injury or death against her. And therein lies the problem. And that's why that's the explanation for what the PCR court said here in focusing on that as a reason, as the most important reason for granting summary judgment, that given that testimony, there can be no genuine dispute of material fact as to whether trial counsel was ineffective for not presenting battered partner syndrome evidence. Now, there is a possibility, there's a possibility that trial counsel might not have known that that was the testimony that Linn was going to give. If trial counsel did know that, then there's no way that it could have been a breach not to retain that expert, because it would have known going in that the testimony would have been this was an accident. If trial counsel didn't know that was going to be her testimony, that establishes that there can be no prejudice, because whatever expert trial counsel had put on, and that expert, like the ballistics expert, presumably would have testified before the defendant and explained reasons why a partner trapped in a cycle of abuse who sees no other way out may become more objectively reasonable for them to take some sort of preemptive or preventative action. And then the defendant gets on the stand and says, no, this was an accident. Couldn't have changed the result.
Well, but maybe, I think you're right. We have no idea. The record doesn't establish what counsel was thinking really at all. We don't know whether counsel was aware of battered spouse syndrome. Might have been aware and maybe made a deliberate choice not to do it, but we don't know. We have no idea. It is possible that had counsel been aware of battered spouse syndrome, would not have put the client on the stand, would have, conceivably the whole defense could have changed significantly had counsel been aware. That's at least a possibility, I think, but tell me that's not correct.
I think it's a possibility, although a defense of self-defense justification when they're the only two people in the room, to put that forward without Linn's testimony, I think would have been extremely difficult and very unlikely to succeed. But beyond that, I admit that is, on both of our parts here, speculation.
Well,
right?
We should have had a record. If we're going to evaluate counsel, don't we need to have some kind of record to understand exactly what was going through counsel's mind?
And the record we do have is mostly the trial transcript. And counsel answered the interrogatories. Most of them say investigation is still ongoing. By the time it comes around, resistance to the motion for summary judgment is basically, I don't have facts for this. The pro se defendant has a right to present her claim. And I think that looks a lot like the resistance in Jones, or what happened in Jones, where counsel says, I can't give you facts to resist this, but my client has a right to do so herself. Now, and I think that to say that this is ineffective assistance of PCR counsel does not allow for the possibility that there may have been investigation done that turned up facts that were unfavorable that, if introduced, would be harmful to Ms. Linn's claim. On this topic of PCR counsel ineffectiveness, the lack of a record means that I don't think it's appropriate to adjudicate this here. I definitely don't think this is structural error, because we have participation in the case, answers to interrogatories, filing what we would presume is the best available resistance to the motion for summary judgment. And there's no getting over, the transcript of trial testimony reflects what happened. You can't beat those facts.
I'm right about the timing that the expert motions were filed before and then the resistance was filed later and was just kind of a boilerplate resistance. Is that?
I think that's correct. I don't know that I'd say boilerplate because it does, it does focus on gamble and trying to preserve a right to raise pro se claims in some manner. But I do agree that at the very least, the first motion for an expert was filed well in advance of that motion for summary judgment. And I'm not sure about the second, but I believe you're right.
About the record on prior violence toward her previous to that night?
I think that she definitely doesn't describe it. She may make a kind of a veiled reference to it, I believe, because reading through it the first time, I had assumed that she had described it, and then going back to try to find where that was, I couldn't really find descriptions of those prior incidents. But I think that what she definitely does say, you're correct to say, is that and I think opposing counsel mentioned this, is that whatever she's talking about, whether it's just threats or it's threats and abuses, within the last 2 weeks. And I think this is a good jumping off point for talking about battered partner syndrome generally. There are two kinds of battered partner syndrome cases. One of them is amenable to being where a defensive self-defense justification can be raised normally, where you're dealing with a hot confrontation, imminent use of force that would inflict serious injury or death, where a traditional justification defense can be raised the normal way with here are facts known to the defendant, creating in their mind an imminent expectation of lethal force. Now, the other category of battered partner syndrome cases are the preventative or preemptive action cases, the stereotypical case where the victim is killed in their sleep because of an expectation of future abuse, somebody who's trapped and sees no other way out other than that preventative or preemptive action. And this is absolutely not applicable to Miss Linn. Blanchard was already moving out. We have phone calls to both Scott and Kreese establishing that was happening. He meets her on the street and says, "I left the keys in your bird box. Goodbye." And she invites him back in. She's the breadwinner. He's not controlling her economically.
It would have been interesting to have an expert review the file and say, well, I've looked at you know what the experts got to say. They look at the file. I've looked at the trial transcript. I've looked at the medical evidence, blah, blah, blah. And here's my opinion. Now, we don't know. We have no idea what that opinion might look like. And doesn't that give you pause? I mean, I nice medical affidavit, but we really don't have that developed on the record here.
The volume of cases on this topic and law review articles and notes and all written by lawyers who are not doctors. This general concept is understandable to lawyers, and I'd submit lay people, maybe not the ability to render a diagnosis in a particular, or if a diagnosis is possible. And where I'm going with this is the idea that trial counsel's decision to not call or retain or consult an expert at whatever stage it advanced to, the decision to pick up the phone and call is made ex ante without knowledge of what the person on the other end of the phone is going to say. The decision whether or not, and we've in other contexts been able to say it was a reasonable strategic decision not to exhaust all possible routes of investigation, not to undertake this particular.
But I'm sorry to cut you off, but this may well have been a reasonable decision. Frankly, it could have been a reasonable decision of trial counsel, maybe. I mean, they may have had a little soiree around the table saying, look, we have this battered spouse syndrome, but under the facts of this case, I don't think it's a good idea. It's going to drive you into first-degree murder, da-da-da-da-da. It could well have been maybe a reasonable judgment, maybe. On the other hand, it could have been, as you say, it could have been no awareness problem. It could have been, oh, we'll find an expert, and then they forgot to find. I mean, who knows? We just don't know. Ordinarily, we direct ineffective assistance counsel claims to PCRs, to develop the record so we can figure out what was going on in counsel's mind, and then we come to a judgment. But we don't have that situation here at all.
And I would submit that it is the resistor's burden when a motion for summary disposition is filed. The resistor's burden to come forward with facts creating a genuine dispute on a material issue. I think that, length aside, pointing to it doesn't take long to communicate the fundamental disconnect between defenses of accident and justification, especially with the trial transcript present for the court to review. And I think that even if it were blank, even if there were nothing in the motion for summary judgment other than petitioner has failed to carry the burden to introduce facts showing that trial counsel breached a duty and that she was prejudiced, that burden is on the applicant. And the applicant has a burden of production to meet, to show the existence of some dispute on, and we start with a presumption of trial counsel's competence.
I don't think that's, in all candor, I don't think that's right. I think the burden's on the moving party. Let me help you, though. The memorandum that was filed simultaneously by the state, the 8-9-page memorandum, I don't know, that does have 4 or 5 citations to the record. And so it seems to me, perhaps, we could say, well, the motion itself didn't have citations to the record, as is generally required in a motion for summary judgment. And the statement of material facts not subject to dispute did not have citations to the record, as is normal. Okay, well, we could say, well, but the citations in the memorandum ought to be considered as kind of a part of the mix, perhaps. But on a motion for summary judgment, aren't we ordinarily limited to the kinds of argumentation that's been presented by the party? I mean, and has the state really met its burden of shifting anything?
I think the state very definitely met this burden here by pointing to the inapplicability of the battered partner syndrome theory to the case as presented at trial with this trial testimony, and then also pointing to the answers to the interrogatories and the progress in the case during its pendency, the PCR case, showing that, after all this time, there's still been no production, no unearthing any material, any fact showing a genuine dispute on the issue of whether trial counsel breached a duty, whether this is really a failure to investigate, whether there was a duty to investigate here at all. And I want to return to the first question that you asked, because you said, isn't there a difference between trial counsel strategically deciding not to investigate this and just not being aware of battered partner syndrome at all? I'd say there is a difference, and that could become relevant and has been relevant in some cases. On this record, it is possible, and I think from the Court of Appeals opinion and the PCR court's opinion, and I think that's well supported, that even if counsel were not aware of the existence of battered partner syndrome, that would not be a breach of duty in this particular case because of its clear unapplicability to the facts as established.
You say as a matter of law, I believe, as a matter of law, when the defense to a homicide is accident, battered spouse syndrome as a matter of law is off the table. I mean, I think that's your position.
I think that it's not our only position, but I think it is true. I think that is true.
That's what the district court, I think, said. I mean,
That is what it indicated as the most important fact supporting its ruling. And I think that is true, because if you're saying that it was an accident, so you're admitting that you had no subjective belief in that the imminent use of force was impending and that it was reasonably necessary for you to use lethal force in self-defense.
But then you have the inconsistent defense of justification, which has been advanced, and it's not unusual to ride 2 horses, it seems to me.
Sure. I think that you made the comment that the battered partner syndrome defense could have pushed the jury into first-degree murder. I think there's a very clear danger of that by saying, presenting syndrome evidence that people in similar situations have made the decision to preemptively or preventatively murder their partner. I think it's a really tricky proposition to advance that with accident under any circumstances. But I also think
It's back to my question on this justification. I haven't read the closing arguments. I mean, was justification being asserted in the sense of a self-defense kind of thing, or was it being asserted as a battered partners syndrome kind of thing? Because they're both forms of justification, but it depends on which one you're talking about. It strikes me that a self-defense might not be that inconsistent with her version of events at trial, that they were kind of both grabbing for the gun and it went off and he was killed. But it does strike me that the defense that because of the persistent beating and violence that he had committed with her over time, that in order to in the big picture defend herself, she needed to kill him. That does strike me as inconsistent with the version that she presented. Which one was it? Do you know?
And with your permission, Your Honor, if I could, thank you. It was a little bit of both. Okay. I think it was a little bit of both. It focused mostly on her testimony about what was happening in the moment. That first in those two categories that I gave you, where it's a hot confrontation, and battered partner syndrome evidence is, and I think that plays into it where you, I think counsel rightly identified that painting this as a hot confrontation is the best way to get there. And I think that it means that battered partner syndrome evidence would not have materially furthered that defense, because they're already limited to facts that Linn knew that made it more or less subjectively or objectively reasonable for her to think that use of deadly force was imminent, and that use of lethal force in self-defense had become reasonably necessary. And all of those facts came out about the history between them and what she knew about him and what was happening, regardless of any testimony or any evidence about battered partner syndrome. That remains the same. And I think that it is and all this bears both on prejudice and breach. I think that the breach question is easiest to resolve and must be resolved ex ante, because trial counsel can never know what an expert is going to say when they make the decision about whether to seek an expert's assistance. And I think as a matter of law, especially with the absolutely zero facts disputing what the state had put forward and what was in the trial testimony, and just no showing of trial counsel's unreasonableness, I think that the PCR court was correct to grant summary judgment. And if PCR counsel was somehow ineffective, then the remedy for that has to be to develop some kind of record in a subsequent PCR about what that meant. Thank you.
Mr. Sloven, thank you as well. Mr. Hurd, you may present your rebuttal.
Thank you, Judge. I don't dispute that the remedy in this case is to develop a record, but I think the appropriate place to develop that record is the PCR, remanding this for a PCR hearing on the application for an expert. In returning your question, Your Honor, I think it's important to note that even if there was some gap in time between the application for an expert witness and the entry of the summary judgment, both of those issues, the trial court was aware of both of those issues and decided both of those issues simultaneously in denying the summary judgment. And
The trial court denied the motion for appointment of expert witness, did it not?
they did, and also I think I want to address the additional authority as I put. The motion is actually a motion for investigative services. It's not necessarily a motion for investigative services, although maybe it's ambiguous. But it says that the attorney needs expertise to help to investigate the claim. I think those are services to which an attorney in post-conviction is entitled to apply for, and that issue hasn't been addressed. But the reason that I cited those additional authorities, particularly Iowa Code 815.7, is that that section applies to a non-contract attorney who's appointed to represent an applicant in a post-conviction case. And that section clearly says that the applicant's non-contract attorney is entitled to the expenses of their investigation. Why I think that's important is the state points to Iowa Code 815.4 and says, well, you can't get an expert because an expert's only allowed under the rules of criminal procedure, and this here is a civil proceeding, therefore no expert. The problem with that is, if you're allowed to have an expert, and the only distinction between whether you get an expert or you don't get, not an expert, but investigative services in a PCR, is based on whether you have a contract attorney versus a non-contract attorney with a public defender, that's a glaring equal protection problem, because there's no reason to grant in one category investigatory expenses to non-contract attorneys that are not granted to contract attorneys. And last, judges, I just think the state mischaracterizes this case. This is not a purely accidental death case. There are many elements of this case that a battered women's syndrome expert could diagnose battered women's syndrome and support that with a number of facts that were developed at trial. I'm not going to repeat the facts I mentioned earlier, but other key facts are that Kathy Linn testified that Barry Blanchard told her he killed people. He killed a civilian in the Army. He testified that he killed a civilian while he was on the run in California. We talked about, the state contended this is not a case of economic management. Well, I don't know if the facts support that. The trial testimony from Kathy Linn was that Barry Blanchard actually set up the PIN number for her food stamp card. He would take her money and spend more than is necessary when buying alcohol. He would pressure her to buy drugs, including the night of the offense. In terms of prior violence, there was some testimony, not the most vivid, about the relationship had been violent 2 weeks, but I think the trial court testimony also said that he said 40 times he would slit her, to her many, many times, he would slit her from her pussy to her throat and fuck her even if she's dead, which is not only very graphic violence, but is also sexual abuse, another aspect of the power and control wheel. There are many, many more things that occurred in this trial that would make appointment of a battered women's syndrome expert appropriate. Another one that comes to hand is the trial testimony that was offered by the state that he dared her to shoot her. To a layperson, that might be perceived as an intentional decision by her. A battered women's syndrome expert might view that evidence quite differently, because one of the aspects of the power and control wheel is threats of suicide, threats of violence. And perhaps by saying, a battered women's syndrome expert would say, by daring her to shoot her and her not doing it, he's reinforcing the cycle of violence and the cycle of abuse. There are many, many aspects of this record that would have supported the appointment of a battered women's syndrome expert to aid Ms. Linn in developing a genuine issue of material fact. But even without that on the record, I think the state failed to prove the absence of a genuine issue of material fact, for each being the one they failed the most. There's no affidavit here that trial counsel considered battered women. There's no affidavit here that trial counsel even knew about battered women's syndrome. I think it's clearly a duty of trial counsel, and I've seen my time's expired. I'd like to just finish up briefly. The Duluth model on domestic abuse was developed in 1979, and in 1994, this court accepted the final report of the courts and communities' response to domestic abuse, which incorporated the Duluth model in its analysis. In 1999, this court accepted the final report on domestic violence and mediation. This court, and importantly in that report from 1994, the court notes the Duluth model is widely accepted in the field of domestic violence. And when a defense counsel or a post-conviction counsel is not abreast of models that are widely accepted in dealing with the issues that are central to their case, they certainly breach a duty. Prejudice is apparent by the many examples of how battered women's syndrome expert would be useful that we've discussed today. So for those reasons, Your Honors, I'd ask the court reverse the decision of the Court of Appeals, remand this case to a trial court reverse the judgment of the trial court and remand this case to the trial PCR court for a hearing on the application for an expert and a reset summary judgment proceeding. Thank you.
Mr. Hurd, thank you as well. Mr. Sloven, thank you again. The case of Linn versus State is now then submitted. We'll next hear arguments in the Board versus Knoll.